Welcome to the American Bar Association and the Alabama State Bar's continuing legal education program, Legal Ethics for Pro Bono Lawyers. My name is Jean Dowdle Rasco, and I am a member of the Alabama State Bar's Pro Bono Celebration Task Force, along with Linda Lund, our Director of Volunteer Lawyer Programs for the Alabama State Bar, and our speaker today, Professor Jeff Baker. We are so excited that you are here today joining us for this very special CLE as our nation prepares to kick off National Pro Bono Week. And we are also excited because we know that your hearts and priorities are in the right place because you are a pro bono lawyer. For those of you attending in person, we have microphones set up so that you can participate in today's lecture. If you have any questions or comments, please join in. I know Professor Baker would like that. And now it's my honor to introduce you to Professor Baker. Jeffrey R. Baker is Associate Professor of Law and Director of Clinical Programs for Faulkner University Thomas Good Jones School of Law. Professor Baker received his undergraduate degree in political science and vocational ministry at Harding University, and he received his law degree from Vanderbilt University. Professor Baker directs clinical programs and he teaches and supervises in the Elder Law Clinic, the Family Violence Clinic, and the Externship Program at Jones School of Law. Professor Baker is an accomplished author, and he routinely demonstrates the essence of a pro bono lawyer, which is that lawyers should devote professional time and civic influence to ensure that the nation's poor receive adequate legal representation. Professor Baker.
Thank you, Jean. That's very kind. Good morning, all. Welcome to this continuing legal education program. Gotta put on the mic. On legal ethics for the pro bono lawyer. Is that good? This event today, as Jean said, is sponsored by the Alabama State Bar and our task force on pro bono celebration. I am a member of that task force, and I want to say thanks to a few people before we get underway with our presentation. I want to thank our bar president, James Pratt, our immediate past president, Elise Spruill, who has just such a heart for this work and access to justice, and to Jimbo Terrell, who has chaired this very active task force this year. I should say James instead of Jimbo, but he's known and loved. I also want to thank, as Jean did, Linda Lund, who's the director of the Alabama State Bar Volunteer Lawyer Program, and Jean herself, a fellow member of the bar and someone who is deeply dedicated to providing volunteer lawyer services, even when she doesn't want to and can't afford it. She still does it because she does have such a heart for her community and her clients. And I want to thank Freedom Court Reporting in Montgomery for providing the videography today, because this is going to be provided on our website for Pro Bono Celebration at the Alabama State Bar, and also on the American Bar Association's Pro Bono Celebration website as well for national consumption. Throughout the presentation, I'm going to be talking about ideas related to poverty and practice among poor people, and I'm indebted and will be sharing some ideas and insights from Martha Delaney of the Volunteer Lawyers Network and Dr. Ruby Payne, who writes thoughtfully and usefully on issues of poverty, including her book, A Framework for Understanding Poverty, which I recommend to you. Access to justice issues for poor people are perennial. They are exacerbated in times when public and private resources are diminished for the support of legal aid and legal services. Our state of Alabama trails the nation in public support of legal services for poor people and access to justice initiative. But the work of our volunteer lawyer programs and the bar is extraordinary and tries to pick up the slack in a state that needs it very much. And so we rely very heavily on the work of heroic, seriously devoted lawyers in private practice to provide civil pro bono services for people in our state. Alabama has a 17 to 18% poverty rate this year, So we know that access to justice for people who cannot afford lawyers is essential, not just for their own well-being, but for the rule of law and for the continuation of our civil society in Alabama. But we also know that this is not a local issue. This is a national concern. It's a national crisis. So we are very grateful that the ABA is going to provide this, among other resources, throughout this month to try to support and encourage lawyers who are providing pro bono services and volunteer lawyering. Today we're talking about legal ethics that pertain to the practice of attorneys that guide and bind us as we engage in pro bono legal services. And just to make our purposes direct, to be very clear of what we're talking about, I mean providing free legal services to poor people. People who cannot afford our services, people who are of limited means and resources and opportunities. I don't think that we should be shy and euphemistic about talking about poverty when we discuss what it is that we are discussing. When we are talking about access to justice issues, when we are talking about pro bono lawyering, it is important to name what it is that we are doing. I think it dignifies our clients when we have a thorough understanding about where they are and what they're doing. So today, when we are talking about pro bono services, public interest, or volunteer lawyering, we're talking about service to people who do not have much money, people who do not have many resources and opportunities. We are talking about representing, advocating for, advising, and counseling clients who cannot pay us. Now, at the risk of invoking class warfare or anything in our current environment, I do want to be clear about some assumptions that I'm making and some of my biases in this. Poverty is real, and being poor makes a difference in someone's life experiences, what they're going through, how they make decisions. We humans, all of us, I think, have to resist the temptation to give traction to the old bias that wealthy people are wealthy because they somehow are more righteous and more deserving of the wealth that they have, that they are somehow rewarded for being who they are, and that poor people are somehow less valuable because they have somehow come to deserve their plight. These are ancient biases that if you are rich, you are good, and if you are poor, you are bad. But they are insidious, and they are destructive, and they are not true, these biases. These assumptions are not true. And I do not mean to sound preachy or accusatory when I say this, but I do want to say that I believe that this is a bias that we all have to struggle with, that our society and our culture and our profession struggles with, and we have to name it, and we have to reckon with it as we discuss the ethics that are going to bind our profession together. Now, today I'm not talking about redistribution. I'm not talking about entitlements or rights or privileges or who deserves what or when they deserve it in the matter of wealth and poverty. What I'm talking about is the reality that lawyers face when we embark on this good work. If we embrace the nobility of our profession, if we embrace the motto that we have here at the Alabama Bar, that lawyers render service, if we take our motto seriously, that we do render service by donating our time and talents to our neighbors who are poor, then our duties and obligations as lawyers attach to them just as well as they apply to our paying and wealthy clients. And that is my broad thesis for the day. My broad thesis for the day is that our legal ethics, our duties, our obligations as attorneys are every bit as important, if not more important, and critical to our pro bono clients as they are to our fee-generating practices. We may not provide lesser services. We may not provide less ethical lawyering to clients merely because they are not paying us. This may seem obvious and indisputable, and if we were in professional responsibility class or taking the MPRE, we surely would say that this is true, but I think it's more difficult in practice than just in theory. Context matters. Our client's context matters to them, and it should matter to us. We must understand our poor clients. We must understand them with the same sophistication and recognize the same ethical issues that arise with our poor clients as we do with our rich clients. A lawyer cannot adequately represent anyone. We cannot adequately represent a bank or an insurance company or the government or a state agency or a wealthy client or a farmer or a personal injury plaintiff without understanding the dynamics of their lives, the dynamics of their business, the dynamics of their decision-making. What are the pressures that are on them to give them thorough representation and to understand what it is that they're facing. Likewise, we cannot adequately represent poor people if we do not understand what it is to be poor, if we do not have a clear, humble understanding of poverty. We cannot do our job well without learning about our clients. And we will not be able to identify the ethical issues that arise when we are representing our clients unless we are conversant with our clients' circumstances. So today, that's what we're going to discuss. In the framework of our professional conduct rules, we're going to talk about the context of poverty, the context of our clients, the circumstances of a poor person, and the nature of pro bono practice, and some of the special ethical issues that arise when we do this good work. Now, since we are providing this CLE to a national audience, I'm not going to rest on any particular state's ethics rules. I'm not going to talk about the Alabama rules of professional conduct, but I'm going to rest our discussion in the ABA model rules of professional conduct, which are very much like what we encounter. So first, let's talk about the scope of the rules. See if I can advance the slide. I have made an assumption. I have proposed a theory to you that I think deserves testing, and I'm going to ask you. And you have mics, so I'm going to ask you to answer as I would to my law students who didn't have any choice. Is it a true statement? Is it a true statement that the rules of professional conduct apply with equal authority to clients who are not paying as they do to those who are?
Yes.
That's pretty easy, I hope. We're going to see how it plays out. But I want to justify myself with a citation. I'm going to begin with the preamble. This is the preamble to the model rules of professional conduct. An excerpt from paragraph 4 says, in all professional functions, a lawyer should be competent, prompt, and diligent. In all professional functions. So can we safely say that pro bono, volunteer lawyering, is a professional function? Yes. Now, paragraph 6. This is regarding the definition of public citizenship. The ethics rules call lawyers, all lawyers, public citizens, and this is part of the implications of that. A lawyer should be mindful of the deficiencies in the administration of justice and of the fact that the poor, and sometimes persons who are not poor, cannot afford adequate legal assistance and should therefore devote professional time and civic influence in their behalf. A lawyer should aid the legal profession in pursuing these objectives and should help the bar regulate itself in the public interest. Are the ethics rules necessary for adequate legal assistance? Are the ethics rules critical to providing adequate legal assistance to our clients? Let me say that another way. Are unethical legal services adequate? No. If we're going to provide legal services, to be adequate legal services, and get this, minimally competent, okay? Minimally competent, adequate, not great, adequate. Adequate legal assistance requires ethical rules, observance of our ethical duties, and how we do it. Now, one more quick, easy question. Do the rules of professional conduct here or in the model rules or in any state make exceptions for people who cannot pay versus people who are paying to be our clients? No. A client is a client, and our duties attach to them. So let us assume that the thesis is correct, that the rules apply to pro bono lawyers providing free legal services for people in poverty. They certainly do. And in a moment, I'll go even farther to say that perhaps lawyers have even a greater ethical duty to the clients who cannot pay, who are in poverty, who may be less sophisticated, who may not be easy, who may not have easy access to the marketplace of lawyers to compare and contrast and compete and to get the best lawyer. these clients may rely more, not less, on their volunteer lawyer than someone who is a paying client, but more on that as we draw toward the end. If the rules of professional conduct, if our ethics precepts apply to our pro bono lawyering, and if we ought not give short shrift to our pro bono clients, then let's consider some specific examples, some specific ethical issues that arise in our pro bono practice among our more vulnerable and marginalized populations. Today I'm going to focus on two critical rules in the interest of time that invoke serious issues in our poverty practice. The first is competence, and then we're going to talk about communication. Competence. Now, of course, this is not exhaustive. These are not the only two ethical issues that arise in poverty practice, but I do them to illustrate the particular issues that arise in our work. I think lawyers encounter these often. Competence. A lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. In the comment to this rule, competence means and is described in terms of legal knowledge and skills, thoroughness and preparation, and maintaining competence. This is the constant, ongoing, lifelong learning and study of the law so that we can do our job well. Now, for our audience, what are the types of legal issues that you encounter in your volunteer lawyer program? In your volunteer lawyering, in your pro bono practice, just give a list. What are some things that you run into? What are the issues that arise mostly?
You mean legal issues or ethical issues?
Legal issues, thank you. Legal issues.
Landlord-tenant?
Landlord-tenant, assuredly.
Contract.
What sort of contract issue?
Whether it's a valid contract or not, or just explaining the terms of the contract.
Sure. We were having a conversation before we got started about consumer financing. And does someone understand the interest rate that they just signed up for? That sort of thing. Gene and I were discussing domestic violence and family law issues, custody issues. What else? What else do you encounter?
Drafting powers of attorney and advance directives.
Powers of attorney and advance directives, especially for elder law practice, for people who are coming in and needing. And I would say also in that wills. Wills, I have found and observed in our experience, become a real easy way to try to punch your pro bono card sometimes, because everybody just needs a simple will, if there's such a thing as just a simple will. That is definitely something. We may encounter immigration issues. We may encounter Medicare, Medicaid, Social Security issues, governmental benefit issues, WIC, unemployment, employment law, wrongful termination. In our clinic yesterday, we had a man walk in who was battling two state agencies in an employment matter and could not afford a lawyer and could not find any pro bono practice that met his needs because he lost his job. So he couldn't pay for a lawyer, but he needed a lawyer to try to get his job back. These are very common issues. Now, we have talked about a pretty wide spread. And in a state like ours, where 2/3 of our lawyers are small and solo practitioners, small firm and solo practitioners, many of you may be competent in all of these things. My friends at Legal Services may be competent in all of these things. How many of you are competent to right now practice family law, landlord-tenant law, consumer protection law, employment law, public benefits law, immigration law, disability rights law? I'm not. Anybody else in here got all those covered? We don't have all those covered. So in our regular practices, in our fee-generating practices, when you are in your law firm and somebody walks in and they present to you an opportunity to be their attorney on an issue, a legal issue that you don't know about, something that you have not done before, what are your options? Just practically speaking, every day, walking around. What do you do if something comes to you and you don't know what it is? You research it because you want the client. It's business, right? So you're going to probably do a cost-benefit analysis to say, is this piece of business worth the time that it's going to take for me to learn how to do this? And is it going to turn into a book of business? And do I now have a new aspect to my practice? Yes. And you're going to set that time apart. What are some other options besides you learning about it yourself? You refer it out, or you refer it down the hallway. If you have a partner, or if you have a law firm, you're going to say, well, my partner knows how to do this, and even though I don't, we're still going to make some money, right? We're going to get a new book of business. Or you refer it to your old law school mate with whom you share cases, or you're going to give it to the law firm in some sort of friendly quid pro quo because they're going to send you business and you're going to send them business. You share space with somebody. This is how we do it. That is the practice of law. That is the business of what we do. Now, how is this standard practice complicated when providing pro bono legal services? If you don't have the promise of payment for this client and someone walks in and you don't know what it is that they're going to be doing, do you have the option to do all of these things? Consider this. Let's say that you're a tort litigator. You're an associate in a big firm in a pretty big market. You do mass tort litigation. But your firm has a pro bono requirement. You have a good heart. You want to do this. You sign up through the volunteer lawyer program, and you decide to take on what is billed to you as a simple will. And you think, I had wills and trust. I got a form. I know some people. I'll do a will. No problem. So you set aside an hour to meet with this client. She comes in. You intend to sit down with her an hour. You hope to only sit down with her for an hour. And you start talking about it, and she mentions her family farm in a rural county. And she thinks she has an ownership in that farm because everyone in the family thinks they have an ownership interest in that farm. Because it's been in their family since Reconstruction, and because they have shared it always. Her grandfather and all of his siblings live there, and all of the grandkids always go there for Thanksgiving. No one has. You ask her about the abstract. You ask her about the chain of title. You ask her about passing it down. She has no idea what you're talking about because it's just the family farm. So all of a sudden, you are faced not with a simple will. You are faced with issues of heir property, cloudy titles, tax liens, future interest, adverse possession, family fights, and even the rule against perpetuities. You have got problems, right? If the rule against perpetuities shows up in my practice, I just rewrite the problem so I don't have to figure it out, right? I mean, we just don't know what it is anymore. So what do you do? Now, you would probably give the case back to VLP, right? You would probably call your state bar and say, I can't handle this. But let's say you're intrepid and you want to keep it. You were competent for the simple will, but are you competent in all of these areas? There may be some people who are competent in all of these areas. I know one really good lawyer in town who is competent in heir property issues and who would be conversant about all of these things. Can you refer it to another attorney in your law firm? In your big tort firm that does mass tort litigation? Probably not. Can you devote the time necessary to learn about all of these things? Not should you, can you? Because you have a good heart, you want to, but can you? Can you afford to not bill out at $200 an hour or $150 an hour while you learn about this? Are you not throwing money out? So now we see the beginning of a problem, not for the lawyer, but for the client, because the client has fewer options for legal services. The client cannot just avail herself of all the lawyers in your law firm. She cannot entice new lawyers to learn something about this because she can't pay for it. And even though you may think that it's a valuable piece of property, it's a long, long time before you're ever going to see any kind of award from this, if ever. So we often see in our practice all the time, not to mention our pro bono practice, a discrete legal issue creep and grow and grow and grow as good lawyers continually dive in and get an increasingly sophisticated understanding of the problem. It grows bigger and bigger and more complex and complicated. Now, under the rules, must we be competent? Yes. Under the rules, should we refer cases for which we are not competent and for which we cannot become competent? Should we do that? Yes. Or should we learn about it? But here is the real problem for people who want to do really good work. Is a little bit of competence mixed in with a little bit of incompetence better than nothing at all? Because that's the real struggle, I think. We all have a tendency to say, well, a simple will is better than no will. But you don't really know that, right? You don't really know what unforeseen consequences, what unintended cause and effects you're going to have in this person's life and her family if you do it this way. It is very easy for us to make a utilitarian excuse for ourselves and say that we are going to do good for someone better than they would get otherwise if we are guessing and shooting in the dark about some issues. Because how are they to know, right? This isn't a competitive marketplace. Who's going to file a bar complaint and win against a VLP who's just trying real hard? I don't know. It may happen, but probably not. And so you're going to think, maybe I can just muddle through, even though you would never muddle through for a rich client. But I suggest to you that this is not just a binary choice. It's not just, are you going to do it or not do it, or are you going to do it and do it halfway? There is a right way, but the right way is just harder and more costly. And I'm a law professor, so I have the benefit of, preaching a little bit and moralizing. And so I don't intend to say that what I'm saying right now is not gut-wrenchingly impractical. But if we are talking about ethics and if we are talking about our better angels, then we would say we have to do it right. And we have to do it right. And we have to dig in. And if we are going to take this client, we have to take this client and do it right. And we have to learn. And we have to know. We have to look up and say, who knows about air property in this town? And then you call that person and you find out and you try to help this client. And then you hope that you can do some good with it. Or, with regret, you decline the case. And you give her advice and counsel as best you can and referrals as best you can. And you try not to let her leave empty-handed, but you don't do a shoddy job for your client. Let's move on to our second rule as we continue. Communication. I won't read the whole rule, but the rule essentially says, a lawyer shall promptly inform the client of any decision or circumstances with respect to the client's informed consent, and reasonably consult with the client, reasonably keep the client informed, comply with reasonable requests for information, consult with the client about any relevant limitation to the lawyer's conduct, all of that. Now, reasonable to the lawyer is not reasonable to the client. We all know this, right? The number one bar complaint in Alabama, and I suspect the number one bar complaint throughout the country against lawyers, is poor communication. It's not calling your client back. It's not returning phone calls. It's not keeping them up to date. Now, we know that often that is very understandable. We're busy. Our clients think that they are our only clients. We all struggle with this. I am not preaching against the realities of law practice here. Our clients often do not know what is a reasonable request for information. Our clients often demand developments because they think all of the slow parts of practice are edited out like a TV show, right? And they think that things are going to happen like this when in fact they're not. The wheels of justice grind slowly. You know that, but they don't. And so you get in this bind. Now, here's the ethical temptation, right? Are you more likely to return calls to a client who is paying you $250 an hour? That's the Alabama rate. That may not be the New York rate if anybody's in here watching this on the web. The $250 rate, which is lucrative in Montgomery, or are you more likely to call back the client who is paying you nothing? Who is more important to your practice? Who's more important to paying your bills and paying your secretary, paying your internet service provider? And I don't intend to be preachy or judgmental, but I do want us to be honest about our work. And I think that this raises three issues. First is this practical problem, just as I illustrated. We're in the rush of our practice, and we can't always communicate with our clients that as well as they would prefer. But the second and perhaps harder problem is this one that starts with B, section B of the code section, the rules. A lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. What might be our tendency for pro bono clients when they present with a problem? You want to help them, right? You want to solve their problems. But let's say that Jimmy, here's my hypothetical, let's say that Jimmy and his family live in HUD Section 8 housing, but he is concerned about persistent mold in the house. He's worried that it's making his kids sick, and he wants to know, 1, how can he get testing for it? 2, can he sue the landlord? 3, can he break his lease? Can he force the landlord to make repairs? And whether any of these things that he's doing, is it going to affect his Section 8 eligibility to get subsidized rent? Hypothetically, let's also say that because you know landlord-tenant issues, let's say you know that the best thing that he can do is provide written notice, 30 days, and get out. Let's just say you know that. Let's say that that is the right answer. Which is easier? To just tell the client what to do, or to explain to the client sufficiently for him to make an informed decision regarding the representation? What's easier?
Tell him what to do.
To just tell him what to do. Gene and I were talking before our session today about how easy it is to just tell a client, sign here, sign here, sign here, sign here. We're going to solve your problem. Because we are problem-solving people. That's what we do, right? That's what we're hired to do. So what is easier, to just do it, or to advise and counsel our clients so that they can make an informed decision? Well, we know which is easier, but which is better, and which is more ethical? Do we just tell our paying clients what to do? Sometimes, but not if they don't want us to. Sometimes our paying clients will just tell me what to do. And sometimes they'll say, just tell me what to do so you don't have to spend another hour thinking about this that I have to pay you for, right? But it is always going to be more efficient to just solve the problem. But the ethical rule is to explain a matter to the extent necessary to permit the client to make an informed decision. Because rarely are we our client's agent, just sent out to do for them. We are advisors and counselors and advocates, and above all, we are representatives. We represent our clients. We do not tell them what to do. We are not their bosses. So I suggest to you that if the rules apply to everybody, if a client is a client, then the ethical response here is that we should advise, counsel, educate, and inform our clients so that they can make their own decisions. We should do that for all of our clients, every one of our clients. Now, the third problem to this is related, and it is inextricable. For you all who have experience doing this, what are some of the practical barriers between you giving advice to a client and the client understanding how to make an informed decision? What stands between you and clear communication with your pro bono or client?
Pro bono or paying, it's your legal education.
Absolutely. It's your education. And how does that affect your ability to communicate?
You have years of study and practice pent up in your mind, and they don't. And you can either take 8 years to explain what you've learned over the last 8 or 10 years,
right,
or you can just say, sign here.
That's right. We are in this area experts. We are more sophisticated. We have our own language. We speak in legalese, and we know what we're talking about. And our clients don't. And that is for sure a barrier. At least our vocabulary of technical language. But even more than that, an expertise in some matter in depth in the law. Now, what else? That was top of my list. But what else? What else stands between us and our clients?
Getting them to our transportation.
Absolutely. Just physically making the meeting happen can be extraordinarily hard because if you live in a place like we do in Montgomery that has pretty good public transportation, or like most places in a rural state that have no public transportation, and you're dealing with a poor client without transport, or who actually literally has to pay for gas as she goes, that's going to be a huge problem. You may have to go to her. And if you have to go to her, that creates a whole different set of problems, right? What if your client's prepaid phone goes out? How are you going to communicate with them? These very physical, important barriers. Now, I mean, I care about what my phone charge is, but I can't tell you right now how much my bill is this month. Mostly because my wife does the bills, but mostly because it's real. My life is not truly affected if my bill goes up by $5. It's just not. If gas goes up $1, I'm still going to do what I'm going to do. But most of our pro bono clients aren't, and it's going to very much affect. That is a critically good idea. What else is going to stand between you and your clients? Think practically, think esoterically. Gene, what's going to stand between us and our clients?
They can't read.
If they can't read, Alabama has a 20 to 25% rate of adult functional illiteracy. We're not alone in that, but it is a critical problem to understanding, especially if you're working in a rural, poor place, that many of your clients can't read. And then it becomes extra easy to just say, sign here, and we'll solve your problem. But that is also much more dangerous because probably if it's a contract action, that's what got them in trouble in the first place. They signed something they couldn't read and couldn't understand. And what is all wrapped up in not being able to read when you are talking to a well-educated lawyer?
You don't understand what they're saying, probably.
Right, and because you don't understand what is going on around you, how do you feel as a client?
Intimidated and not comfortable and untrusting.
Intimidated, untrusting, uncomfortable. How else? Embarrassed, worthless, humiliated. And so that is going to present an immense communication barrier, one that may not be obvious, one that may not stand out like, I don't know what that word meant, or I can't make it to the meeting, but one where you are saying something to someone, and then you say, do you understand? And they say, what? Yes. Regardless of whatever the answer is, they're going to say, yes, I understand. And that is an immense barrier to overcome when you are trying to communicate with someone, and not just communicate to them the words that you know and the concepts that you know, but communicating to them to the extent reasonably necessary so that they, not you, they, the client, not the lawyer, can make a decision. When we teach law students in our clinic, which has a poverty law practice, I tell them that we lawyers bear the burden of communication. We have to accept the burden of communicating with our clients, regardless of who they are, regardless of whatever the barriers are. If we are trying to communicate a concept, if we are trying to educate our clients as lawyers, then any failure to communicate is on us. Now, that's not in the rules. That is Baker's Model Rule 22. That we bear the rule, that we have to bear the burden of communication. I think that is a moral problem. I think it's an ethical problem, because if you're going to communicate with a client, you cannot blame a lack of communication on your client who can't read, or who didn't go to law school, or who is poor, or went to a really bad school, or didn't go to school at all, or who has been frankly, oppressed by the situation into which they were born. That burden is on us. Clear communication requires speakers and listeners who are engaged with each other, and it is the lawyer's job to ensure clear communication. It is not the client's job to decipher our code, because that is not what the rules say, and we also know that we cannot get away with that. We will not do a good job. So I suggest to you that we should take all steps necessary to communicate to a client so that she understands what we're talking about, even if that means taking a really long time to do it. And I want to guard here. Some people say that means we have to dumb down our language. I don't like the term dumbing down. I don't like the condescension that is implicit in that turn of phrase. I want you to think, and I want us all to think, in terms of translating, not dumbing down, translating our language. Because what we're really talking about here is a difference in dialect, a difference in language, a difference in vocabulary. It's not that someone is more or less natively intelligent because they are poor or wealthy. It is that language is going to develop in such a way that you have got to be able to translate. We have got to be multilingual lawyers. We've got to be able to speak to whomever we are speaking to. And I try to tell the students, especially as they are coming out of law school, you need to be able to work with the most sophisticated, highest people. You need to know which fork to eat with. You need to know when to fold up your napkin. You need to know how to have a lunch with somebody. But you also need to know how to talk to the person in a neighborhood that you have never been in before, and in the kind of home you have never been into before. Talk to a person who doesn't look anything like you in a humble way, in a way that respects who you're trying to talk to. We speak lawyer language to each other, and that's fine. But we have to remember how to speak the various dialects of lay language as well, and we have to practice translating our technical language, our lawyerly language, so that our clients can make informed decisions, not just to do what we tell them to do. And above all, we must listen to our clients, not just speak at them, not just speak to them, not just to describe the world to them. We must listen to them, and we must hear them. Context is everything, and if we do not understand our client's life in the context, in the dynamics of their lives, we will not be able to listen and hear them. We wouldn't do this to a big bank client. We wouldn't say, I don't care anything about the SEC. Let's just talk about how to make you some money. You can't do that. You have to know the context in which they're living. You have to know the politics. You have to know something about what's happening. You have to do that with a client too, with a pro bono client. If we don't hear them, if we don't listen and hear them as they are reflecting back to us what we are saying, then we cannot communicate. And if we cannot communicate, then we are not competent. And if we are not competent, and if we cannot communicate, then we are not ethical. And if we are going to be ethical, we have to be all of those things. So now I want to turn, as we move toward our close, from the rules a little bit, from the ethics rules to just a little bit of moral calculus on pro bono lawyering. And I want to ask you to consider whether or not we actually owe a higher duty to our pro bono clients, not a lesser duty to our pro bono clients. Let me ask you a little bit of class discussion. What is the difference, do you suppose, between the concepts of pity and compassion? Someone define pity as related to compassion.
Pity, you feel sorry for somebody. Compassion is more empathy.
Sure. Pity is when you feel sorry for someone. This is a great working definition. Compassion is when you feel empathy for them. Now go another step, Professor Hamlin, and talk about what empathy is.
Understanding how they feel and not judging them.
I think those are deeply critical concepts. Not judging them and seeking to understand how they feel. Now, we just covered that a little bit when we were talking about communication, that you have to understand where your client's from and then not judge them. And judgment goes way back to the beginning where I said we have to guard against this bias to say that a person deserves whatever their situation is. Maybe they do. Maybe they don't. And we don't know that until we get into understanding them. Why do you think this matters to a pro bono client? For people even of goodwill, why do you think this distinction is going to make a difference? What is our natural tendency as lawyers, as people, as human beings? Pity or compassion?
Pity is probably natural.
Pity is, and it is natural. And don't hear me say that we should not feel sorry for people, right? It's also easier to feel pity than compassion with someone. How might pity manifest itself to a lawyer who encounters a poor pro bono client, even with a goodwill, to be condescending to them? And how do you think that might manifest itself?
It could be your tone, the words you choose to speak with them, even how you look at them. Did you shake the hand when they came in? All those things could affect your communication with the client. Absolutely.
Are you going to give them a firm handshake and look them in the eye? Right? This is what we do. I want to draw a little bit of a conceptual distinction here between two other concepts. We have pity and we have compassion, which are related but not the same. And we also have two other concepts, the concept of charity and the concept of justice. Charity and justice are both good things, but they are not the same thing. Charity is what I would say is more closely aligned to pity. And don't hear me and say that I don't think charity is wonderful. Charity is wonderful. But charity takes care of this person's problem right now. Justice is concerned about why this person is in this problem to begin with and how do we try to get them out, right? You can have a clothes closet at your church. And the clothes closet is very important because you are going to clothe someone who needs help. That's charity. That's good. It's valuable. Justice is when you say, how did you get here? Why don't you have any clothes to begin with? And how can we try to solve that problem? For you, for your family systems, for your community, for your nation, for wherever you're going, how are we going to address these issues as private actors, as public actors, as citizens, as lawyers? Those are the things that we are trying to work on. And my final note today is going to ring in this context between pity and compassion, between charity and justice. And I will say this: I believe very deeply that no one likes to be a charity case. No one wants to be your pro bono project, right? Nobody is happy to be helpless and dependent on other people, especially other people's pity. Rather, almost always, people will prefer to be empowered themselves to confront their own challenges, to preserve their own self-respect, to overcome their own problems, to overcome their own obstacles. And as lawyers, as we've said, we are accustomed to problem solving. We are driven, A-type, successful, professional people. We see a problem, we know what the elements are, we know what the burden of proof is, we know what the standard of review is, and we do it, right? That's what we do. We identify an issue, we research the answer, we propose a solution, we implement a strategy, and we work for a good outcome. And of course, we should do all of those things for a pro bono client. But I suggest to you that we should resist the temptation. We should resist the temptation to just solve their problems. We should avoid being one more person in a long line of people who have just told that person what to do. I believe that very deeply, that our job as lawyers is not to just tell them what to do. Our job as lawyers, and especially for clients in poverty, especially for poor pro bono clients, it's not just to tell them what to do, it's to help them do better. It's to help them understand their own situation and to empower them and educate them and give them resources in such a way that they don't have to keep coming back, that whatever this problem is can be solved and then they can move on. So I suggest to you that instead of feeling sorry for the plight of the poor client and then deigning to condescend to address it for them, we should instead address it with our clients. Not just for them, but with them. And I think this is an essential matter of human dignity. Dignity that will understand how to get in touch with your client, because even if she doesn't have a Twitter account. or to shake her hand and to look her in the eye, or him when he walks into your office. Let's pull alongside our clients instead of just trying to solve their problems. If there's a legal decision to make, let's help them make it. Let's educate them, counsel them, advise them so that they make the decisions themselves. Then, with a better understanding of her own needs and her own goals, let us, as her lawyers, as his lawyers, as his community's public citizens, empower them to confront them for herself. Now, on a bigger macro level, I don't think that this is just better service to the client. I don't think that this is just better lawyering. I think this is a matter of justice. When we can help someone regain their dignity, when we can help them promote themselves in their community, we make the communities better. And compassionate lawyering makes for better lawyering because we demonstrate to the community and to all of our people our competence, our diligence, our loyalty, our zeal, our honesty, our ability, even our nobility as a profession. So volunteer lawyering is not just for pro bono credit, and it shouldn't just be for charity or pity. It's a matter of justice. If we are able to take good care and provide competent, excellent, ethical legal services for our clients, for our pro bono clients who can't pay, and if they are able to engage in our legal system, then that supports the rule of law, it supports our civil society, and it helps empower the dignity of people who are our neighbors, who are our citizens, and who are human beings. That is truly for the good, and that's what we're all here to talk about today. All right, thank you all for your attention today, but thank you mostly all for being dedicated to this work, for being interested in what it means to be a lawyer, for seeking justice in the world, and for doing good. So now go forth and do some good. You're dismissed, and to ensure that you get credit for this ethics hour, make sure you sign out, and you have an evaluation form to fill out, so be nice. All right, thank you all.